Let's cut right to the bottom line. On average, how much money are leave of absence lawsuits worth? If your company violated your FMLA rights, should you pursue a case? If you're in California and the company violated your CFRA rights, what should you do? These are very important questions. I'm here to give you honest answers. My name is Branigan Robertson, and I'm an employment lawyer. Before I go back to the whiteboard and detail all of this out, I have a few preliminary things that you need to know. First, please realize that there is not an easy answer to this question. You're probably thinking, just tell me some statistics, Branigan, so I can know how much these cases are worth. Well, quality statistics for this stuff doesn't exist because 98% of cases with lawyers like me settle and are sealed with a contract. So if you really want an honest answer to how much money FMLA cases are worth, then keep watching this video. I promise to explain how the legal system values these cases. Second, case value depends dramatically on your circumstances. So we are going to answer the question by exploring the topic from 3 different circumstances. Number 1, if your leave of absence rights were violated and you were fired from your job. Number 2, if you quit your job after your rights were violated. And number 3, if you're still employed but the company is violating your FMLA rights. But don't skip ahead. Each part of this video builds upon its previous parts. If you skip ahead, you won't understand what I'm talking about. Third, I've made detailed videos about the rights that the Family Medical Leave Act, which is also known as FMLA, and the California Family Rights Act, CFRA, what those laws grant employees. Those videos dive deep into those laws, what they actually do for you, and identify who qualifies for a leave of absence and who doesn't. If you are in California, I highly recommend you watch my CFRA video. If you're outside of California, I recommend you watch my FMLA video. Links are below in the description. Fourth, even though I'm a California lawyer, I made this video for everyone in the United States. This video is not legal advice, it simply lists the basics on how damages work. To get an idea if you have a case and how much it might be worth, you need to call a lawyer. If you are in California, here is my contact information if you think I'm worthy of your phone call. If you're not in California, this video will raise critical questions that you should get answered by a lawyer in your state. Okay, let's jump in. We are first going to look at answering this question as if you were fired or terminated. Let's pretend that you were fired unlawfully. In our hypothetical, it doesn't matter if you were fired because you requested a leave of absence or if you were fired after taking a leave of absence. The common denominator is that you were fired in violation of FMLA or CFRA. In that case, there are several different types of damages that you may receive in a leave of absence lawsuit. Number 1, lost wages. 2, liquidated damages. 3, emotional distress. 4, punitive damages. 5, attorney's fees. And 6, sometimes we can get intangible stuff in a settlement. Let's take them in order. Let's talk about lost wages. Lawyers call these economic damages. These damages look at your past and future lost wages. Lost wages are the backbone of employment law, and the best way to explain them is with an example using nice round numbers. Let's create a hypothetical case and say you are earning $100,000 a year at your job. Then you get pregnant or you become injured or something like that, and you need to take a protected leave of absence under FMLA or CFRA. But your boss doesn't like that and fires you. Well, you're not making $100,000 a year anymore. So how does this play out? Let's say you were unemployed for an entire year, and then you found a new job earning over only $50,000 a year at the beginning of year 2. Your case goes to trial at the end of year 2. How much lost wages would you get? Well, in our example, you would first calculate past lost wages. So year 1, you were unemployed, so that's a $100,000 loss. Year 2, you had a differential because you made 50, but you were making 100. So there's a $50,000 differential. So your total past economic damages are $150,000. Next, let's talk about future lost wages, because past lost wages are not the whole picture. In a case, your lawyer is going to hire a fancy economist who's going to project out into the future how much money you are going to lose as a result of the unlawful activities. So let's say the economist comes up with a formula and a projection that each year you're going to get a raise of about $5,000 a year. So your salary is $50,000 a year, and each year you're going to make $5,000 more. Well, in year 3, after trial, you're making $55,000, so your differential is $45,000. Year 4, you're going to make $60,000, so you're going to have lost $40,000. Year 5, $35,000. Year 6, $30,000. Year 7, $25,000. So in total, over the next 5 years after your trial, you will lose $175,000 in future economic damages. So when you add your past economic damages of $150 with your future economic damages of $175, your total lost wage damage picture is $325,000. Next, we need to talk about liquidated damages. In FMLA cases, you can also recover liquidated damages in a leave of absence case. The law says that you may recover an additional amount equal to the entire award of your lost wages. So in our example, if you have $325,000 in lost wages, the court may award you another $325,000 on top, bringing your case value so far to $650,000. That's awesome, but there are some bad things about liquidated damages. First, you won't win these if you're in California. This only applies to FMLA. But that is okay, because if you are in California, likely you'll bring your case under CFRA, which is a much better law as it allows you to collect certain types of damages that you usually can't get under FMLA, namely emotional distress and punitive damages. Those are very powerful and usually overwhelm what liquidated damages would do for you. Second, you can only win liquidated damages if the court finds the violation was made in good faith, was not made in good faith. Basically, the court may choose not to award you liquidated damages if it finds the company acted in good faith and had a reasonable cause to believe it was not violated FMLA. So this gives the court and the jury a reasonable out to avoid awarding you liquidated damages. In my opinion, I think it's going to be relatively rare that an individual is going to get double their lost wages in liquidated damages. Next, we need to talk about emotional distress. Emotional distress damages, also known as pain and suffering damages, are awarded to employees who receive significant emotional distress injuries as a result of their leave of absence rights being violated. For example, let's say you're pregnant and you're entitled to a leave of absence under CFRA, but your employer denies your leave and fires you. You're going to be extremely emotional and upset about that. Or let's say your 8-year-old son is diagnosed with leukemia and you need to take time off under FMLA to care for him. If your company denies your leave of absence request, you're going to be devastated emotionally. Now, there is good news and bad news about emotional distress damages. The bad news is generally these damages are not available under FMLA. You are not going to recover emotional distress damages under an FMLA type case. There are exceptions, but generally you can't recover these damages, and that's a big bummer. However, the good news is that in some states, like California, you are allowed to win emotional distress damages because you're bringing the case under a similar statute to FMLA. In California's case, it's CFRA. But let me make a couple other things very clear. Emotional distress injuries are not something that you can fake. You can't fake it until you make it. You are evaluated by experts who testify in front of the jury, and these damages are very real and can be several times larger than your economic damages. But seriously, okay, you're probably asking, how do you put a dollar value on upset feelings, hurt emotions? Well, how we do it is we hire experts who testify as to that person's change of behavior, their identity, was it tied up in their job, did the person seek professional psychological help, and we build a case and we present that case to the jury. And the jury decides the actual dollar amount. How much do you get or how much do you not? To continue with our hypothetical example, let's say the jury found that the violation was significant and they awarded you $500,000 in emotional distress damages. When you add your lost wages of $325,000 to your emotional distress damages, that brings your total verdict to $825,000. Not bad so far, but we're not done yet. Next, we need to examine punitive damages. Everybody on the planet has heard about punitive damages. These are the damages meant to punish the company from truly atrocious behavior. And the idea is to deter the company from behaving badly again in the future. Unfortunately, you can't win punitive damages in an FMLA case. But if you are in California, you will likely bring a wrongful termination claim as well, where you can win punitive damages. And since CFRA is part of the FEHA statutory scheme, you can win punitive damages as well. Now, punitive damages are very hard to win. You have a much higher burden of proof because your lawyer is going to have to convince the jury that your rights were violated with malice, oppression, or fraud. This is a higher burden, and it's far more difficult to do than most people think. Now, everybody who calls this thinks that their case is worthy of punitive damages, but statistically that's just not true. I would say in less than 10% of employment cases are punitive damages even seriously considered. However, if you do win them, they can be as high as 9 times your underlying compensatory award. So right now, when you add lost wages with emotional distress in our current hypothetical, that's $825,000. You can win 9 times that. Now, when I'm looking at cases, I don't even consider punitive damages. I don't think it's wise to even think about them because they're so speculative, especially at the beginning of the case when you haven't gathered the evidence, you haven't done depositions or anything like that. But for our purposes of having our example, so far you've won $825,000, you can win 9 times that. In theory, you could win $7.4 million in punitive damages. I mean, that's just crazy talk, right? So let's just assume for our hypothetical that the jury is really angry at the company. They think that they acted with malice, oppression, or fraud, and they award you $500,000 in punitive damages. That brings your verdict from $825,000 to $1.325 million. Not bad, but we're still not done yet. Next, we need to talk about attorney's fees. In leave of absence cases, if you pursue your case all the way to trial and you win, the law allows the employee to recover attorney fees on top of everything else they've already won. While this doesn't directly benefit the client, because the attorney fees go to the attorneys, it does directly benefit the client in the vast majority of cases when the cases settle. Why? Because this statute increases the leverage that you have in settlement negotiations. Here's how it works. Let's say you go to trial and you win, but you only win a small amount, say $25,000. That's a small verdict, but the bad company will still be on the hook to pay your lawyer. And that could be a 7-figure dollar check, even though it's based on a $25,000 verdict. There are several published cases in California where an employee won small, but the company still had to pay a small fortune to the employee's lawyer. This directly benefits you because the company knows this when it comes time to negotiate a settlement. And they're going to be willing to pay a little bit more to settle the case because they don't want to be stuck paying your lawyer. Settlement in employment law is all about leverage. In theory, the more leverage that you have, the more money you will settle your case for. This part of the video ignores the formal boxes of damages that we just discussed and focuses in on the intangible points of leverage that can dramatically increase the value of your case in settlement. First, facts. What actually happened to you? How bad was the violation of law? When presented to a jury of people who don't care about you and they don't care about the company, is the jury going to be outraged with the company, or are they going to think that it's not that big of a deal? Second, media. Is there a genuine threat of media coverage? Honestly, this is pretty rare, but when it does exist, it can really increase the value of your case. Third, Honesty. Honesty is always the best policy, right? Did you tell the truth during your deposition? Does the company and its employees, do they tell the truth? If one side lies, it increases the other side's leverage. Look, every single time one of my clients has lied to me or lied under oath, it has dramatically decreased the value of their case. So please, just tell the truth. Next, temperament. This is a massive factor in case value. What is the temperament like of the person signing the check? Is it an emotional business owner who would rather sink their company than make a prudent business decision? Or is it a rational business person who's going to just make the logical choice? Next, insurance. This is really important. Is there an insurance policy that covers this claim? If so, what are the policy limits? What's the adjuster like? Next, how good is your lawyer? Believe it or not, but aside from the facts of the case, this is the single largest variable that increases or decreases the value of your case. If you pick a good lawyer, one that you trust and that really fights hard, this can dramatically increase an otherwise mediocre case. But on the other hand, if you hire a bad lawyer and you have a good fact pattern, you're never going to settle for very much money because bad lawyers don't know how to use good facts. So please, pick a good lawyer. So far, we've only talked about people who were fired. Let's now talk about the folks who quit their job. Generally, if you quit after having your leave of absence denied, you can still file a lawsuit, but there's a really big problem. Unless you can establish that your resignation qualifies as a constructive termination, you cannot collect your lost wages. The law establishes that if you voluntarily quit your job, you are not entitled to recover economic damages in an FMLA or CFRA lawsuit. Well, what exactly is a constructive termination, Branigan? In the context of this video, a constructive termination is when, due to the employee having a legal right to take a leave of absence, the employer makes the working conditions so intolerable that a reasonable person in the employee's position would have had no reasonable alternative except to resign. Now, most people think that they qualify under that standard, but honestly, it's really hard to win a constructive termination claim. In my opinion, judges and juries absolutely hate them. As a result, it's hard for people who quit their job to find a good lawyer to pursue their case. Now, I've taken constructive termination cases in the past, but I'm very picky, and I have good reason to be. If I'm going to invest thousands and thousands of dollars of my own money into the case and hundreds of hours of my time into the case, I need to be confident that I'm going to recover enough money to make it worthwhile for my client. Well, let's talk about other types of damages. You're probably asking yourself, well, if I can't get my lost wages, what about, pain and suffering, punitive damages, and attorney's fees? Yes, even if you quit, you can still recover other types of damages so long as they're legally available to you. But unless extraordinary circumstances exist, it's usually a losing strategy. Why? Because lost wages are measurable and easily understood by juries, experts, and the opposing lawyers. In my opinion, lost wages are a metaphorical key that kind of unlocks the other types of damages. So is it worthwhile to file a FMLA lawsuit or CFRA lawsuit if you quit? Maybe. I've taken constructive termination cases before and I've settled them for a lot of money. In those cases, we had excellent proof that the working conditions were totally unacceptable, and I was 100% convinced that any member of the jury in a similar situation would have resigned without hesitation. But in those cases, extraordinary circumstances existed. So if you are in California and you believe extraordinary circumstances applied to you and you quit your job, feel free to contact my office for a free consultation. Hey, real quick interruption. If you're still watching this video and you think it's been helpful, please give it a thumbs up on YouTube and subscribe to my channel. If you know somebody whose leave of absence was denied or if they were fired after taking a leave of absence, please share this video with them. They will thank you for it. All right, let's finish up. Finally, let's talk about if you're still employed, but your FMLA or CFRA leave of absence rights have been violated. If you're still employed, you are still earning your salary, commissions, or hourly wages. So unless you were demoted significantly and your pay was cut in a sizable way, you haven't lost a lot of money. This situation is very similar to the constructive termination scenario we discussed just a few minutes ago. This makes it really hard to pursue a lawsuit if you're still employed. Now, there's always exceptions to this, but generally, if your FMLA or CFRA rights are violated and you're still employed, lawyers like me usually tell folks two things. Number one, complain about the violation of law in writing. If you're going to do this, I highly recommend that you watch my video on how to complain properly. Legally speaking, it's very important that you complain correctly. So I strongly urge you to watch that video once you finish this one. I'll put a link in the description. Secondly, we also tell people to call us back if they get fired. Now, I know you're probably thinking, call you back when I get fired, then it's too late, my job is gone. I understand. Unfortunately, the tools that the law has given employment lawyers like me generally are not very effective at stopping violations of law as they occur at work. The tools that we have are far more effective at pursuing justice after the fact. Why is this? Because people are emotional creatures, and lawsuits are like throwing a lighter into a pool of gasoline. If you sue your company while you're still there, you're painting a giant target on your back. Nobody at the company is going to want to see you succeed. They're going to want you to fail, and they will watch you with a microscope and document every perceived failure that you have. So is it worthwhile to pursue an FMLA lawsuit if you're still working at the company? Generally, we recommend waiting until you're fired to pursue a case. But there are always exceptions to the rule. So if extraordinary circumstances apply to you, don't be afraid to call a lawyer for a consultation. So to conclude, the ultimate question becomes, should you pursue your case? Well, I can't answer that question in a video because I don't know you. I don't know the facts of your case, and I don't know what's important to you. But what I can tell you is this. If you're able to find a good lawyer that you trust, who believes in your case, who you've spoken with personally, and who is willing to invest time and money into the case, then you should probably pursue it, because for the most part, lawyers like me only get paid if we win. Unless somebody has a lot of money and they're willing to pay us by the hour, we generally don't take cases unless we believe with every fiber of our soul that we can achieve a great result. Anyway, I hope you found this video to be helpful. If you think I've earned your phone call and you're in California, don't be afraid to reach out to my office for a free consultation. We handle leave of absence cases all the time. That's all I have for you. I hope you have a fantastic day.